Welcome to the compliance updates for August 2022 in the Northeastern region. In Maine, the Federal Appeals Court, Maine's cannabis licensee resident requirement is unconstitutional. On August 17th, the First Circuit Court of Appeals affirmed that the holding of the U.S. District Court for the District of Maine that the residency requirement of Maine's Medical Use Marijuana Act violates the Dormant Commerce Clause, DCC. The First Circuit has added itself to the list of jurisdictions that have invalidated similar state cannabis laws on DCC grounds, including in the 6th and 8th Circuits. So real quick, this Dormant Commerce Clause is extremely important. It's going to have a lot of repercussions. Obviously, we're seeing it here with the residency requirement, but there's also going to be things about interstate commerce that's going to come from this as well. We've covered it in previous month updates, so definitely go back and check that out on a more robust breakdown on the DCC. So Northeast Patients Group, otherwise known as Northeast in this article, and High Street Capital Partners, known as High Street, sued the Maine Department of Administration and Financial Services in 2020. The complaint challenged Maine's requirements that all owners of the medical marijuana dispensaries must be residents of the state. The First Circuit's decision effectively eliminated all residency requirements for becoming a cannabis license in the state of Maine. The history here was interesting. In 2020, the state issued policy guidance stated it would not enforce the residency requirement for cannabis licenses in the recreational marketplace. There, the state was advised by the Attorney General that the residency requirement for adult use cannabis licenses would not withstand DCC scrutiny. Northeast put the theory to the test. Northeast owns and operates 3 medical marijuana dispensaries in Maine and is wholly owned by 3 Maine residents. High Street is a Delaware corporation that is owned entirely by non-Maine residents. High Street wanted to purchase all of the equity in Northeast, but because High Street has non-residents owners, the Maine Act prohibits High Street from becoming the owner of Northeast dispensary operations. Admirably, to complete their transaction without creating a convoluted business structure of dubious regulations legitimacy, which we see a good deal of, the plaintiffs filed a lawsuit challenging the Maine's Act's residency requirement under the DCC. In general, the DCC prohibits states from enacting laws that place substantial burdens, discriminate, on interstate commerce. This means that when a state enacts a law that regulates interstate economic activity by favoring its own residents, as with Maine's residency requirement, it must be narrowly tailored, quote unquote, narrowly tailored. Broadly speaking, this means the state must be able to justifiable the discriminatory law. That's the rub. Maine and many other states requirement that medical marijuana licensees be state residents is clearly discriminatory against non-residents. In this case, Maine did not dispute that the law was not narrowly tailored, and as a result, the First Circuit found it unconstitutional. The DCC has been used to invalidate many state laws similar to Maine's residency requirements for cannabis licensees. In 2019, the Supreme Court invalidated Tennessee's 2-year residency requirement for owning a retail liquor store. However, in the cannabis context, there are several unresolved questions among central of the federal circuit, including whether the DCC is applicable to cannabis in the first place due to the plant's federal illegality. The First Circuit held that the DCC is not preempted by the fact that the Controlled Substance Act, CSA, makes marijuana production, possession, and sale unlawful. Further, it states that the CSA and DCC are, quote, distinct. And the argument was used by a federal court in Oklahoma in 2021 to throw out a case making a DCC challenge to the state's residency requirements for cannabis licenses. There, the court dismissed the case without considering the merits of the DCC claim by invoking the, quote, clean hands doctrine. The court stated it would not use its power to facilitate federal illegality conduct. Yeah, interesting stuff with the DCC. So we'll see how this all plays out with the Dormant Commerce Clause. All right. Another one out of Maine. So Maine's adult use market hits a milestone while competing with caregivers. So in a state renowned by a vibrant, laissez-faire medical market full of caregivers, Maine's adult use market is approaching a pivotal moment, having grown to the point where the state is ready to take off the cultivation training wheels. The state is approaching the 2-year anniversary of the first issuance of an adult use cultivation license. As part of the anniversary, the state will stop allowing the transfer of plants and seeds from the state's medical program. At this point, the state has 72 adult use cultivation sellers. The state has 72 adult use cultivators selling to 101 retail licenses. So it's time to see if the state's adult use supply can stand up on its own. Although a common refrain in states with nascent adult use markets is that the biggest competition comes from the illicit market, in Maine, the competition largely comes from the medical caregiver market, per this article. Last month, I spent a week in Maine from the article, which gave me a chance to check out one of the state's adult use retail stores. As a Bay Stater, I visited Maine plenty of times, but this was my first trip since the state finally allowed the first adult use shop to open. All right, shifting on over to Massachusetts. Massachusetts legislature passes Host Community Agreement, HCA's reform legislation. So Massachusetts legislation has proposed new limitations on community impact fees, which may change the dynamic of the relationship between licensees and their host communities. Once effective, the Cannabis Control Commission would be charged with reviewing the community impact fee provisions of both new and existing HCAs for compliance. Specific limitations on community impact fees include a prohibition on fees tied to a percentage of gross sales. Cannabis businesses should carefully review the specific language of their HCAs and consider next steps to reduce or eliminate these fees. And another one out of Massachusetts. So this is just a potential adverse health effects related to some cannabis products. So when it comes to adverse effects, here's the article right here, just letting you know what's going on. But so when it comes to adverse effects, you need to consider a couple of different things. What's an adverse effect versus a actual product recall? Usually an adverse effect comes before the product recall. The adverse effect, when you're a retailer, you also need to consider your communication plan and how you're going to communicate this to your customers, especially the ones that received those batches. I know that can be a bit challenging with like anonymous transactions and things like that, but you still need to consider what your communication plan. You also should probably standardize this flow too. So when you do receive an adverse effect complaint, that this individual is able to submit a form. You have all of the data that you need, like what happened when they consumed this product, what was the batch of the product, if it's known, product type, brand, all of that fun stuff. All of these things are really important to help standardize within your operation to make sure that you are capturing all the information, retaining your records, because this will be part of your requirements for business records and retaining those records, and most importantly, keeping the public safe. Okay, switching on over to New Jersey. So just a quick article out of New Jersey. New Jersey reports 70, almost 80 million in total rec sales since market opened. So that's really exciting. Yeah, so sales began April 1st, the day after 420, and then through June. And so they've done close to 80 million in total sales. Tax revenue, 4.6 million. And this includes nearly $250,000 in social equity excise fees. And they say that the market is improving. It's performing as well as expected with the current number of dispensaries, the spread of locations, and the high prices. Yeah, there's for sure going to be high prices right now because basic, economic supply and demand, low supply, high demand, higher prices. And this is probably going to be some of the best margins that these retailers are going to receive, because usually the first 18 months are some of the best margins. And especially because the East Coast, we're waiting for all of that to open up right now. As more states in the East Coast open up, margins aren't going to be as great because, people can travel state to state. But right now, is a good time for these retailers to have open stores. They did see a small decline in the first quarter of 2020, but total sales for medical cannabis have ticked up as well. So that's great news for New Jersey. Just another quick article about a retailer. They stopped their deliveries after cyber attack. So this was a Canadian cannabis retailer and distributor. I just want to, throw this in here just because of having a plan for a cyber attack is very important, and also something that you should be communicating to your customers if you're retaining their information. I definitely recommend getting like a cybersecurity consultant and things like that. And then of course, once when like federal legalization happens and we have to contend with HIPAA laws, some states still do require HIPAA laws. You just want to make sure that you're staying in those regulatory requirements. And most importantly, that your point of sale is, and you're asking the right questions to make sure that your point of sale is actually meeting those requirements. All right, and another one out of New Jersey. So aspiring New Jersey cannabis operators are struggling to find real estate and financing. This is a really important article, and I actually have clients right now that are in the middle struggling with this. We've already submitted their conditional license. We're waiting for annual approval, and we just don't have a facility yet. It's really tough when only 78 out of the state's 564 municipalities allow adult use retailers. That's extremely low. And the other thing that's not working in their favor right now is within the annual application, you actually have to have a written approval from the local municipality that you are approved to operate within that local municipality. And each municipality is only approving a handful of retail licenses. So let's just put a number on it. Let's just say that one municipality is going to allow for 3 retailers in their jurisdiction. And within that municipality, if they're only going to allow for 3 licenses, then they're only going to write 3 approvals for that municipality. They're not going to write like 5 or 6 approvals, and then whoever gets their annual license first, they're the ones that get those that license. So it's restrictive all around, not only from which municipalities are allowing and not allowing retail cannabis, but 2, how many are allowed in each municipality, and 3, how many are being approved by the local municipality to operate within that jurisdiction. So super complicated. I mean, New Jersey's trying their best, but unfortunately, I see New York following the same suit right now, because New York's also doing conditional licenses where you don't need the property before you can submit your conditional license. On the surface, it seems great, but we're now finding through the application process and the approval process and actually getting up and operating, it's actually a huge fucking problem. All right, another one out in New Jersey. New Jersey introduced Interstate Cannabis Commerce Bill, which California did something similar to. So this is really exciting to see what this all opening up. State Senate President Nicholas Qatari filed a new bill to allow for interstate cannabis commerce with other legal, medical, and adult use states. The aspirational bill is the latest move in a growing campaign to permit the transportation of cannabis products across state borders, contingent on changes in federal law. The New Jersey state senator filed the legislation as California advanced a similar bill, following a precedent set by Oregon in 2019 and preparing for interstate commerce. The timing of the legislation on the heels of the passage of Marijuana Opportunity Reinvestment and Expungement or MORE Act in the House signals a seriousness in the endeavor. If the bill passes, it would take effect immediately, but the governor would only be able to initiate interstate agreements with permission from either Congress or the U.S. Department of Justice. Really important tidbit there. The governor would have to submit any proposed interstate cannabis commerce agreement to the state legislators, Joint Budget Oversight Committee for review, and the panel would have 60 days to suggest revisions. Potential interstate commerce is contingent on a myriad of factors, including compliance with cannabis laws of the contracting state, compliance with New Jersey rules on public health and safety standards, agreed upon mode of transportation, and provisions to handle public health and welfare emergencies. Additionally, the proposed legislation would not allow cannabis products to be shipped through any state or jurisdiction that does not permit activity. Out-of-state businesses would have to obtain licenses not only from state not only from state regulators, but also from local governments where the activity occurs. Wow, this is so restrictive. According to the language in the bill, quote, any interstate agreement is required to prohibit the commercial transportation of cannabis by any other means other than what is established in the agreement, and also prohibit the transportation of cannabis through any state which does not authorize transportation of cannabis. Any foreign licensee is required to obtain a license from the state and any proper authorization from local jurisdiction prior to engaging in commercial cannabis activity. The bill also contains an equity component to address populations marginalized by criminalization of cannabis in the past. Quote, an agreement shall include provisions determined by the governor to promote the inclusion and support of individuals and communities in the cannabis industry who are linked to populations and neighborhoods that were negatively or disproportionately impacted by cannabis criminalization, the legislation says. Yeah, that is crazy. I mean, I was super curious on how this would all work with interstate commerce, and the fact that New Jersey's like, yeah, but you got to get a state license, and you also have to get local municipality approval, which we just already went over that and how that's a challenge in itself. And then also to be able to actually transport the product and not transport through states that are not, that don't allow for cannabis. So, I mean, it's a step forward. We're trying, but it's really restrictive, and we'll see how it all plays out, you know? So just some additional articles out of New York, since this is a pretty hot topic lately. New York City announces initiative to equitably grow cannabis industry. New York City Mayor Eric Adams and New York City Department of Small Business Services Commissioner Kevin D. Kim announces the launch of Cannabis NYC, an initiative and suite of services to support the equitable growth of cannabis industry in New York City. Housed at SBS, Cannabis NYC will support cannabis entrepreneurs and their workers as the industry develops. The initiative will work with industry stakeholders to create jobs, successful small businesses, and sustainable economic opportunities, while also addressing the harms of cannabis prohibition. Cannabis New York City services will also include the city's first ever technical assistance for cannabis license applicants, as well as other business services to take entrepreneurship beyond licensing to a thriving operation. That's super exciting. All right, New York's accepting dispensary applications this week, but it's still unclear how the program will work. So here's like some high level questions, unanswered questions that the state has yet to answer. How much rent will the current licenses have to pay? Will license winners have to take locations offered by the state, or can they choose and build their own? Will the states have enough locations? There's likely to be a lottery for locations. Yikes, that's just asking for a lawsuit. Does that mean that the state will force 5 New York City-based applicants to take locations in the Finger Lakes? When will dispensaries be ready for occupancy? So essentially through this application process, the state of New York is like getting these locations and, zoning them and getting these locations ready, and then going to give them to the applicants, which is a really interesting model. So I'm excited to see how this plays out. Another one out of New York. This was pretty hype in the news. New York cracks down on unlicensed cannabis licenses. So this is just them going through and, cracking down on illegal activity, which was also, it was also just very convoluted too, because essentially, the governor of New York was like, go buy weed, but there was no places open to go buy weed. So like the everyday consumer doesn't understand these things and doesn't know these things. And so they were just like, okay, I can go buy weed, so let's go do that. And little did they know that they were actually not licensed yet and not approved yet for all of the things. So, and this is just a really great article from Harris and Bricken. This is just an application portal FAQ. So they created this awesome document. We'll link it in the digest so that way you can take a look. But just asking about fingerprinting, what's needed for each applicant, labor peace agreements, insurance requirements. There's a lot here that's really great in this article. So just go take a look. It's a high level FAQ. If you search New York Herd application portal FAQ by Harrison Bricken, I know you'll be able to find it. And then just real quickly in Vermont is opening up their application window, which is super exciting. So they want to issue these licenses by early October. However, licensing retail establishments is complicated. Yes, it is. Part of the decision to open the retail application window early is to give folks plenty of time to complete their application ahead of the October 1st deadline. The board is responsible for making sure the cannabis marketplace in Vermont isn't one that has undermined public or consumer safety. So get those applications started. It's exciting that a new application window is open for Vermont for retailers. So check it out. And that is your compliance updates for the Northeastern region for August of 2022.